FishFAQ.
What is disclosure? Disclosure means making new information known. With respect to patents, there are several different instances of disclosure. Public disclosure of an invention occurs when the details of the invention are published in such a manner that the public can access the information. Since one of the requirements for patentability is that the invention be new, what is disclosed and when is important. If you are disclosing the invention to others prior to filing for a patent application, you could have them sign an NDA, a non-disclosure agreement. While difficult to practically enforce, they at least help solidify the idea that the information is meant to remain confidential. Disclosing the invention to friends and family isn't usually a problem. Since there's an expectation of confidentiality, this type of disclosure won't be considered public and therefore prior art. However, the more others know about an invention, the greater the possibility of it being revealed. Many law firms will have clients sign an invention disclosure form. This is confidential and doesn't count as public disclosure. Public disclosure will occur as part of the application process. The invention will be disclosed through publication approximately 18 months after filing. This disclosure is part of the trade agreed upon between inventor and the patent office. Inventors are granted a temporary monopoly on the invention in exchange for sharing the idea with the public. If you find disclosure unacceptable, you may want to consider proceeding to manufacture with the intent of keeping your invention a trade secret. Be aware that almost all foreign countries have absolute novelty bars. This means that any disclosure you make prior to filing the application will likely foreclose all possibility of securing foreign patent rights. Related to this is the importance of the priority date, the date a patent application is filed. While the priority date isn't disclosure, there is a link. Public disclosure makes the invention prior art, which excludes it from patentability. But in the period between filing and publication, the priority date also protects you, since all other things being equal, the first to file will be given the patent. There is a false notion that an inventor can establish a priority date by sending a sealed letter to himself with the details of the invention. The theory is that the postmark will prove the invention was your idea by the date on the letter. This, however, is of no legal consequence. The law doesn't respect who had the idea first, it respects who filed a patent application first. As always, if you have any questions, contact us at fishiplaw.com.
FishFAQ.